a telecom company spent 7 years fighting over a single comma and won. Then it lost anyway. Rogers Communications proved a Canadian regulator wrong. It proved its own reading of the contract was the correct one. And it still walked away roughly $5 million poor. Two companies, one sentence, and a fight so specific it came down to exactly where one comma sat inside a 100-word clause. This isn't a grammar joke. Lawyers still teach it. In 2002, Rogers signed a deal with Bell Aliot, the dominant regional phone company across Atlantic Canada. Rogers needed to run cable lines across the region, and that meant attaching them to roughly 91,000 utility poles. Poles it didn't own and had no legal right to touch without a signed agreement. Bell Aliot controlled access to those poles. Some it owned outright. Some it simply administered on behalf of a separate power company, New Brunswick Power, under an older arrangement between the two utilities. The agreement Rogers signed locked in a rate of $9.60 per pole every year for 5 years. And that's the entire point of a fixed-term contract. Certainty. Neither side has to guess what next year costs, and neither side can suddenly change the price mid-deal, just because the market shifts underneath them. Then the rules around who controlled those poles shifted, and Bell Aliot found a sentence buried in its own contract that it suddenly liked a lot more than Rogers did. One sentence, 2 commas, and a fight over what those commas were legally doing there. A fight that would take 7 years, 3 separate regulatory rulings, and a second official language to settle. The first crack came from somewhere nobody was watching. In 2003, Canada's Supreme Court ruled that the country's federal telecom regulator, the CRTC, had no authority over provincially regulated power utilities. That's a jurisdiction question. Which government body gets to set the rules for whom? New Brunswick Power, which owned a large share of those poles, was suddenly free of federal rate caps. It ended its own pole-sharing agreement with Bell Aliot and raised its attachment fees from $9.60 a pole to $18.91, with further increases already scheduled for the years after. Bell Aliot was caught in the middle, paying New Brunswick Power's new higher rate while still charging Rogers the old fixed one. So Bell Aliot went looking for a way out of its own contract early. It found one in Section 8.1. Here's what the sentence actually said. The agreement would run for 5 years and thereafter for successive 5-year terms, unless terminated by 1 year's written notice from either party. Read it once, fast, and it sounds simple. Read it as a lawyer, and it splits into 2 completely different contracts. Bell Aliot argued that the second comma, the one sitting right before the word unless, set the entire ending clause apart from the rest of the sentence. In grammar, that's an independent clause, a phrase that can modify everything before it, not just the piece sitting closest to it. Under that reading, either company could cancel with 1 year's notice at any point during the deal, not only at the end of a 5-year term. Rogers pushed back with a canon of its own, the role of the last antecedent. It's a principle of legal drafting stating that a modifier attaches to the nearest phrase it can reasonably attach to, not to everything written earlier in the sentence. Under that reading, the 1-year notice only applied to renewals after the first 5 years had already ended, exactly what a fixed-term contract is supposed to guarantee. Rogers also pointed out something simpler. If Bell Aliot's reading were correct, the words 5 years in the contract would mean almost nothing. A 5-year deal that either side can walk away from with 12 months' notice isn't really a 5-year deal. It's a 1-year deal with extra paperwork. 1 comma, 2 legitimate grammatical readings. And in July 2006, Canada's telecom regulator sided with Bell Aliot, applying what's called the plain meaning rule, the principle that when contract language is grammatically clear, it should be enforced exactly as written. without digging into what either side originally intended. Rogers had just lost the early termination argument over where a piece of punctuation happened to sit. But the ruling that decided this case hadn't happened yet, and it didn't come from a courtroom. It came from a filing cabinet. Canada writes its national contract templates in two official languages, English and French, and both are supposed to carry the same legal meaning. So Rogers went and pulled the approved French version of the same standard agreement, the template Bell Alliant's own contract had been built from, and in French, there was no ambiguity at all. The termination clause specified that notice had to arrive 1 year before the contract's expiration, not at any point during the term, only at the end of it. Two official versions of the same regulatory document meant to say the exact same thing, only one of them had accidentally built a loophole. The English draft had been translated into French years earlier when the model agreement was first approved for national use, long before Rogers and Bell Alliant ever signed anything. Nobody involved in either negotiation had gone back to check whether the two versions still lined up sentence for sentence. In 2007, the regulator reversed its own ruling. Canadian administrative law requires that when one official language version of a bilingual regulatory contract is ambiguous, it has to be reconciled with the other. The two versions exist precisely so a stray comma in one language can't override the shared intent behind both. Rogers had won. The 5-year term was real. Bell Alliant couldn't cancel early. There was just one problem nobody had accounted for. Rogers had won the argument about the comma, but the polls New Brunswick Power owned were never actually covered by that ruling, because the regulator that had just sided with Rogers had no legal authority over New Brunswick Power to begin with. Rogers had won the argument. The law was about to prove that wasn't the same as winning the fight. The 5-year term held. Bell Alliant could not cancel early. On paper, Rogers had exactly the deal it signed in 2002. But New Brunswick Power's polls were never part of that fight. New Brunswick Power was a provincial utility. The federal regulator had no power to set its rates. None. And Bell Alliant no longer had an active poll-sharing agreement with New Brunswick Power either. That agreement had ended back in 2004. Bell Alliant simply could not offer Rogers the old $9.60 rate on those polls anymore. It no longer had the legal standing to. So Rogers had to pay New Brunswick Power directly at the new rate, somewhere between $18.91 and $28.05 per poll, depending on the year, plus a 20% surcharge for poll clearance work. Across roughly 91,000 polls, that difference alone ran into the millions before a single legal bill was added. With retroactive billing stacked on top of years of regulatory filings and legal representation, the total financial impact landed between $2.13 million and $5 million, roughly what Rogers would have paid at the original $9.60 rate across that entire poll network for more than 5 additional years combined. Rogers spent years proving it was right about a comma. The comma agreed. The bank account did not. A regulator agreeing with your reading of a sentence and a regulator having the authority to enforce that reading turned out to be two completely different things. And here's where it gets personal. You've probably never signed a support structure agreement for utility poles, but you've signed a lease, a phone contract, a car loan, a gym membership, and a lot of those documents build their termination clause the exact same way this one did. One long sentence, stacking an initial term, a renewal period, and a notice requirement together, and letting a comma do the organizing work. Find the word unless, provided that, or subject to in your termination clause, and trace it backward. Work out exactly which phrase it's modifying, not just whichever one happens to sit closest to it. Then try reading the sentence with anything set off by commas removed entirely, and check whether the core obligation still changes. If your cancellation date depends on how you interpret a comma instead of a calendar date written in plain numbers, that's worth a second read before you sign, or a call to whoever drafted it. This is also why a lot of modern contracts look choppier than they used to, with short numbered subclauses instead of one flowing sentence. That choppiness isn't bad writing. After cases like this one, plenty of legal departments now separate the initial term, the renewal terms, and the notice requirement into their own labeled sections, specifically so no single piece of punctuation can carry that much weight again. You can read your own contracts with that same instinct before you're the one arguing about what a comma is doing there. So, did the regulator get the grammar right the first time in 2006? Or only the second time in 2007? Tell me which reading you'd have argued. If this one scratched an itch, subscribe. This channel exists for exactly this kind of case. Next week, how one stolen pizza recipe turned into a multi-billion-dollar federal court battle. And the loophole that let a single family recipe hold a corporation hostage for years. That one's worth sticking around for.